Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installation into our Anti-Federalist Paper series going on number 33. So if you haven't gone back and watched 1 through 32, I would highly encourage you to do so because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. Like I said, we're going on to number 33. Now, there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both. And if you haven't already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. All right, so number 33 is titled Federal Taxation and the Doctrine of Implied Powers, Part 2. If you haven't watched the previous lecture, number 32, it is one of the quintessential Anti-Federalist Papers. So please pause now, go watch that one, come back, watch number 33. Excellent. The Federalist writers apparently never responded to Brutus. The following Brutus article was extracted from his 6th essay, published in the New York Journal on December 27, 1787. I don't know how necessarily true that is. If the Federalists, so Hamilton, Madison, and Jay, if they didn't respond to Brutus directly, there were quite a few papers detailing specifically taxation that addressed almost verbatim the points raised by Brutus in the preceding paper. So I'm not sure how true that statement is, but let's say for the sake of argument, the Federalist doesn't in any way challenge the validity of Brutus's arguments. Let's see what arguments he presents here. The general government is to be vested with authority to levy and collect taxes, duties, and excises. The separate states have also power to impose taxes, duties, and excises, except that they cannot lay duties on exports and imports without the consent of Congress. That is true. Even Hamilton acknowledged that in the Federalist Papers. He said the states should retain some power, some extent of power, when it comes to taxes. Here, then, the two governments have concurrent jurisdiction. Both may lay impositions of this kind. But then the general government have superadded to this power authority to make all laws which shall be necessary and proper for carrying the foregoing power into execution. Suppose, then, that both governments should lay taxes, duties, and excises, and it shall fall so heavy on the people that they would be unable, or be so burdensome that they would refuse to pay them both. Would it not be necessary that the general legislature should suspend the collection of the state tax? We see this almost immediately after the U.S. Constitution is implemented with the Whiskey Rebellion, I believe was in 1795. A tax abusive, unrepresentative, and unconstitutional that was enforced at gunpoint by Mr. George Washington. Suspend the collection of the state tax. It certainly would. For if the people could not or would not pay both, they must be discharged from the tax to the state, or the tax to the general government could not be collected. The conclusion, therefore, is inevitable that the respective state governments will not have the power to raise 1 shilling in any way but by the permission of Congress. I presume no one will pretend that the states can exercise legislative authority or administer justice among their citizens for any length of time without being able to raise a sufficiency to pay those who administer their governments. If this be true, and if the states can raise money only by permission of the general government, it follows that the state governments will be dependent on the will of the general government for their existence. What will render this power in Congress effectual and sure in its operation is that the government will have complete judicial and executive authority to carry all their laws into effect, which will be paramount to the judicial and executive authority of the individual states. In vain, therefore, will be all interference of the legislatures, courts, or magistrates of any of the states on the subject. For they will be subordinate to the general government, and engaged by oath to support it, and will be constitutionally bound to submit to their decisions. The general legislature will be empowered to lay any tax they choose, to annex any penalties they please to the breach of their revenue laws, and to appoint as many officers as they may think proper to collect the taxes. They will have authority to farm the revenues and to vest the farmer general with his subalterns, with plenary powers to collect them in any way which to them may appear eligible, and the courts of law which they will be authorized to institute will have cognizance of every case arising under the revenue laws and the conduct of all the officers employed in collecting them, and the officers of these courts will execute their judgments. There is no way, therefore, of avoiding the destruction of the state governments whenever the Congress pleases to do it, unless the people rise up and with a strong hand resist and prevent the execution of constitutional laws. The fear of this will, it is presumed, restrain the general government for some time within proper bounds, but it will not be many years before they will have a revenue and force at their command which will place them above any apprehensions on that score. Go ahead and highlight that. From the fear of this will to that score. Highlight that. Because that was the main critique from Mr. Madison, father of the U.S. Constitution. He said, look, let's just say, for the sake of argument, we don't elect the best of the best, and they become ambitious, and they become tyrannical. The state legislatures will stand in the way. And if not the state legislatures, it'll be the citizens. Do you today, would you today, argue that Madison was correct, or that Brutus was? Do you find that state legislatures and the citizenry have the will, the diligence, and the discipline enough to nullify, to counteract, to put in check overreaches conducted by the federal government? I'll leave that for you to answer. How far the power to lay and collect duties and excises may operate to dissolve the state governments and oppress the people, it is impossible to say. It would assist us much in forming a just opinion on this head to consider the various objects to which this kind of taxes extend in European nations and the infinity of laws they have passed respecting them. Sounds very familiar here. Perhaps, if leisure will permit, this may be essayed in some future paper. It was observed in my last number that the power to lay and collect duties and excises would invest the Congress with authority to impose a duty and excise on every necessary inconvenience of life. As the principal object of the government in laying a duty or excise will be to raise money, it is obvious that they will fix on such articles as are of the most general use and consumption. Because unless great quantities of the article on which the duty is laid is used, the revenue cannot be considerable. We may therefore presume that the articles which will be the object of this species of tax will be either the real necessaries of life, or if not those, such as from custom and habit are esteemed so. I will single out a few of the productions of our own country, which may, and probably will, be of the number. Cider is an article that most probably will be one of those on which an excise will be laid, because it is one which this country produces in great abundance, which is in very general use, is consumed in great quantities, and which may be said not to be a real necessary of life. An excise on this would raise a large sum of money in the United States. How would the power to lay and collect an excise on cider and to pass all laws proper and necessary to carry it into execution operate in its exercise? It might be necessary, in order to collect the excise on cider, to grant to one man in each county an exclusive right of building and keeping cider mills and oblige him to give bonds and security for payment of the excise. Or, if this was not done, it might be necessary to license the mills which are to make this liquor and to take from them security to account for the excise, or, if otherwise, a great number of officers must be employed to take account of the cider made and to collect the duties on it. Porter, ale, and all kinds of malt liquors are articles that would probably be subject also to an excise, the Whiskey Rebellion. It would be necessary, in order to collect such an excise, to regulate the manufactory of these, that the quantity made might be ascertained, or otherwise security could not be had for the payment of the excise. Every brewery must then be licensed, and officers appointed to take account of its product, and to secure the payment of the duty or excise before it is sold. These are natural deductions that you have to make from this infinite powers clause, the necessary and proper clause, and then the taxation clause. Many other articles might be named which would be objects of this species of taxation, but I refrain from enumerating them. It will probably be said by those who advocate this system that the observations already made on this head are calculated only to inflame the minds of the people with the apprehension of dangers merely imaginary. Yeah, that's exactly what Hamilton did. And he's not innocent of it either, Mr. Madison. Madison did it a couple times too. Jay never talked about taxes, from what I remember. You're more than welcome to revisit the Federalist Papers series. He only wrote 5, maybe 6, maybe even 4 to 6 of the Federalist Papers. So you're welcome to go back and watch the John Jay Federalist Papers. And hey, tell me I'm wrong. I'm more than willing to admit that I'm wrong. But that's exactly what they did. That's exactly what the Federalists did. They completely dismissed these totally legitimate deductions and inherent deductions from something like giving Congress a universal power on taxing, or a universal power to tax imports, excises, and duties. That there is not the least reason to apprehend the general legislature will exercise their power in this manner. To this, I would only say that these kinds of taxes exist in Great Britain and are severely felt. The funny part about that is frequently the Federalists in their papers referred to the examples in Great Britain. So for them to refer to Great Britain's parliament or the monarchy when contrasting that with the U.S. Congress and the U.S. executive to be, but then not to compare or show the similarities between the taxation systems, was purely hypocritical. But the Federalists, except for Madison, weren't the most logically consistent or intellectually honest. Madison eventually admitted that he made a horrible mistake with the U.S. Constitution and proved that self-proclamation whenever he wrote the Virginia Resolutions, that was plural, Virginia Resolutions of 1798. The excise on cider and perry was imposed in that nation a few years ago, and it is in the memory of everyone who read the history of the transaction what great tumults it occasioned. That's worth reading about. This power, exercised without limitation, will introduce itself into every corner of the city and country. It will wait upon the ladies at their toilet, and will not leave them in any of their domestic concerns. It will accompany them to the ball, the play, and assembly. It will go with them when they visit, and will on all occasions sit beside them in their carriages, nor will it desert them even at church. It will enter the house of every gentleman, watch over his cellar, wait upon his cook in the kitchen, follow the servants into the parlor, preside over the table, and note down all he eats or drinks. It will attend him to his bedchamber and watch him while he sleeps. It will take cognizance of the professional man in his office or his study. It will watch the merchant in the counting house or in his store. It will follow the mechanic to his shop and in his work, and will haunt him in his family and in his bed. It will be a constant companion of the industrious farmer in all his labor. It will be with him in the house and in the field, observe the toil of his hands and the sweat of his brow. It will penetrate into the most obscure cottage, and finally, it will light upon the head of every person in the United States. But Anti-Federalists, you have no worry because we included the no capitation tax clause. So, y'all are all wrong. Your concerns are all misplaced and imaginary. Thank goodness. You had John Jay, who was arrogantly ignorant. You had Hamilton, who was maliciously neglectful. And you had Madison, who was incredibly naive. Those three schools of thought, those three individuals, were not successful in their convincing the majority, but were successful in implementing, not ratifying, this inevitably despotic government, which would inevitably be brought about by the U.S. Constitution. To all these different classes of people, and in all these circumstances in which it will attend them, the language in which it will address them will be give. A power that has such latitude, which reaches every person in the community in every conceivable circumstance, and lays hold of every species of property they possess, and which has no bounds set to it, but the discretion of those who exercise it. I say, such a power must necessarily, from its very nature, swallow up all the power of the state governments. I shall add but one other observation on this head, which is this. It appears to me a solecism for two men, or bodies of men, to have unlimited power respecting the same object. It contradicts the maxim which saith, quote, no man can serve two masters. The one power or the other must prevail, or else they will destroy each other, and neither of them effect their purpose. It may be compared to two mechanic powers acting upon the same body in opposite directions. The consequence would be, if the powers were equal, the body would remain in a state of rest, or if the force of the one was superior to that of the other, the stronger would prevail and overcome the resistance of the weaker. Very fitting allegory. Not allegory, metaphor. I guess you could say it's an allegory, a metaphor. But it is said by some of the advocates of the system that, quote, the idea that Congress can levy taxes at pleasure is false, and the suggestion wholly unsupported. The preamble to the Constitution is declaratory of the purposes of our Union, and the assumption of any power not necessary to establish justice, etc., provide for the common defense, etc., will be unconstitutional. Oh, thank goodness. We're electing angels who are going to obey every single rule, even though they virtually have none, because the U.S. Constitution is so vague, so equivocal. But hey, our concerns, the concerns of the Anti-Federalists, who perfectly prophesied, basically prophesied, the tyranny we experience today, their concerns in 1788, 1787, 1789 were misplaced, were ill-founded. It turns your stomach reading through these Anti-Federalist papers. Besides, in the very clause which gives the power of levying duties and taxes, the purposes, so he's still quoting the Federalist, the purposes to which the money shall be appropriated are specified to pay the debts and provide for the common defense and general welfare. Oh, thank goodness. It can only be, the taxes collected can only be to pay for the debt and provide for the common defense and general welfare. That's it. Can't be used for unconstitutional programs. Definitely can't be used for a standing army or armies, because the Constitution says no, they can't do it, so it's not going to happen. Thank goodness. You're right. We shouldn't believe our lying eyes. We shouldn't believe the realization of the warnings that the Anti-Federalists told and alerted everyone to back in 1787, 88, and 89. So now this is Brutus, no longer the Federalist. He says, I would ask those who reason thus to define what ideas are included under the terms to provide for the common defense and general welfare. Fantastic question. Are these terms definite? And will they be understood in the same manner and to apply to the same cases by everyone? No one will pretend they will. Go ahead and highlight that. No one will pretend they will. Not even the Supreme Court. Not even 9 people who are supposed to know the U.S. Constitution like the back of their hands can provide a definite definition of common defense or general welfare. Yet these are the only things restraining the federal government. Bupkis. It will then be matter of opinion what tends to the general welfare, and the Congress will be the only judges in that matter. Doesn't that sound familiar? To provide for the general welfare is an abstract proposition which mankind differ in the explanation of as much as they do on any political or moral proposition that can be proposed. The most opposite measures may be pursued by different parties, and both may profess that they have in view the general welfare, and both sides may be honest in their professions, or both may have sinister views. Doesn't that sound familiar? Good grief. They knew. And they just didn't listen, or didn't care. Depends on if you're a cynic or an optimist. Those who advocate this new constitution declare they are influenced by a regard to the general welfare. Those who oppose it declare they are moved by the same principle, and I have no doubt that a number on both sides are honest in their professions, and yet nothing is more certain than this, that to adopt this constitution and not to adopt it, cannot both of them be promotive of the general welfare. It is absurd to say that the power of Congress is limited by these general expressions, quote, to provide for the common safety and general welfare, as it would be to say that it would be limited had the Constitution said they should have power to lay taxes, etc., at will and pleasure. Were this authority given, it might be said that under it the legislature could not do injustice, or pursue any measures, but such as were calculated to promote the public good and happiness. For every man, rulers as well as others, are bound by the immutable laws of God and reason, always to will what is right. It is certainly right and fit that the governors of every people should provide for the common defense and general welfare. Every government, therefore, in the world, even the greatest despot, is limited in the exercise of his power. Excellent quote. Go ahead and highlight that. For every man, bound by the immutable laws of God and reason. Even the greatest despot But however just this reasoning may be, it would be found in practice a most pitiful restriction. The government would always say their measures were designed and calculated to promote the public good. How many times have we heard that one? And there being no judge between them and the people, the rulers themselves must and would always judge for themselves. There are others of the favorers of this system who admit that the power of the Congress under it with respect to revenue will exist without limitation and contend that so it ought to be. John J. Alexander Hamilton. It is said the power, quote, to raise armies, to build and equip fleets, and to provide for their support ought to exist without limitation because it is impossible to foresee or define the extent and variety of national exigencies or the correspondent extent excuse me, or the correspondent extent and variety of the means which may be necessary to satisfy them. This, it is said, quote, is one of those truths which, to a correct and unprejudiced mind, that's definitely Hamilton, carries its own evidence along with it. It rests upon axioms as simple as they are universal. The means ought to be proportioned to the end. The persons from whose agency the attainment of any end is expected ought to possess the means by which it is to be attained. This part right here is what gives it away, that it's Madison. Or not Madison, Hamilton. He's so dismissive, and he always plays on ad hominem in virtually all of his writings. This same writer insinuates that the opponents to the plan promulgated by the convention manifests a want of candor in objecting to the extent of the powers proposed to be vested in this government. Because he asserts with an air of confidence that the powers ought to be unlimited as to the object to which they extend, and that this position, if not self-evident, is at least clearly demonstrated by the foregoing mode of reasoning. But with submission to this author's better judgment, I humbly conceive his reasoning will appear upon examination more specious than solid. The means, says the gentleman, ought to be proportioned to the end. Admit the proposition to be true, it is then necessary to inquire, what is the end of the government of the United States in order to draw any just conclusions from it? Is this end simply to preserve the general government and to provide for the common defense and general welfare of the Union only? Certainly not. For beside this, the state governments are to be supported, and provision made for the managing such of their internal concerns as are allotted to them. It is admitted, quote, that the circumstances of our country are such as to demand a compound instead of a simple, a confederate instead of a sole government, that the objects of each ought to be pointed out, and that each ought to possess ample authority to execute the powers committed to them. The government, then, being complex in its nature, the end it has in view is so also. And it is as necessary that the state governments should possess the means to attain the end expected from them as for the general government. Neither the general government nor the state governments ought to be vested with all the powers proper to be exercised for promoting the ends of government. The powers are divided between them. Certain ends are to be attained by the one and certain ends by the other, and these taken together include all the ends of good government. This being the case, the conclusion follows that each should be furnished with the means to attain the ends and to which they are designed. To apply this reasoning to the case of revenue, the general government is charged with the care of providing for the payment of the debts of the United States, supporting the general government, and providing for the defense of the Union. To obtain these ends, they should be furnished with means. But does it thence follow that they should command all the revenues of the United States? Most certainly it does not. For if so, it will follow that no means will be left to attain other ends as necessary to the happiness of the country as those committed to their care. The individual states have debts to discharge, their legislatures and executives are to be supported, and provision is to be made for the administration of justice in the respective states. For these objects, the general government has no authority to provide, nor is it proper it should. It is clear, then, that the states should have the command of such revenues as to answer the ends they have to obtain. To say that, quote, the circumstances that endanger the safety of nations are infinite, quote, and from hence to infer that all the sources of revenue in the states should be yielded to the general government, is not conclusive reasoning, for the Congress are authorized only to control in general concerns and not regulate local and internal ones. Oh, but the Supreme Court disagrees, and whatever the Supreme Court says goes. Yeah, well, the founders disagree with the Supreme Court. The peace and happiness of a community is as intimately connected with the prudent direction of their domestic affairs and the due administration of justice among themselves as with a competent provision for their defense against foreign invaders, and indeed more so. Upon the whole, I conceive that there cannot be a clearer position than this, that the state governments ought to have an uncontrollable power to raise a revenue adequate to the exigencies of their governments. And, I presume, no such power is left them by this Constitution. Signed, Brutus. Excellent. So that's all that gentleman had to say in number 33. If you have any questions about what was said in 33, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.